Somireddy Law Group is a full-service law firm. We are headquartered in Ashburn, Virginia, with offices in Princeton, New Jersey, Durham, North Carolina, and an international office in Hyderabad, India. We offer our clients a wide range of services that include immigration, civil and criminal litigation, employment and business law, corporate law, mergers and acquisitions, wills and trusts, and family law. We assist both businesses and individuals in their immigration and legal needs. And a brief on today's presenter, Mr. Santosh Reddy Somireddy, the founding partner of Somireddy Law Group. Mr. Santosh Reddy has extensive experience in business immigration law and primarily focuses on his practices on immigration, corporate, and litigation law. Mr. Reddy received his Juris Doctor degree from University of District of Columbia David E. Clark School of Law, where he was the recipient of the prestigious Earl H. Davis Award for Top Clinical Performance. He also holds a master's degree in civil engineering from Bradley University in Peoria, Illinois, and a bachelor's degree in civil engineering from Usmania University in Hyderabad, India. Mr. Santosh Reddy Somireddy is currently licensed in the Commonwealth of Virginia, state of New Jersey, and the state of North Carolina. Just a brief disclaimer before today's presentation. Please note that this should be considered as a friendly discussion. Hence, you should not act upon any of the information that we share in the presentation without first seeking advice from a qualified legal professional. Either Somireddy Law Group or any other organization associated with this presentation assumes responsibility or liability for any errors or omissions in the content of today's discussion. Further, this does not create any attorney-client relationship. Also, before we move on to the presenter, I also want to give small tips regarding how the session is going to be organized today. Please keep yourselves on mute. Please do not interrupt the presenter. If you have any questions, raise your hand or type a message to either me, the host, or the presenter directly. Keep your questions brief and do not present any identifying information about yourself, your social security number, or any of such information. Please do not present any of those. Due to time constraints, we can only allow one question per participant. If we feel that we have more time, we'll allow the flow for more questions. We might not be able to get to all of your questions today. So if you have any more questions and want to get further clarifications, you can always schedule a consultation with us. And for that, you can email us to info@somireddylaw.com. And then before we start the presentation today, sorry, sir.
I think I would like to go through this portion.
Yes, sure, sir.
Yeah.
Over to you, Mr. Santosh.
Yes. Good evening, everyone. As Mani did already the introduction, my name is Santosh Reddy Somireddy. I'm the founder of Somireddy Law Group. One small correction. Actually, we will be licensed in 14 states. Right now, we're licensed in Virginia, New Jersey, New York, Michigan, North Carolina, Washington, Georgia, Pennsylvania, and Maryland. So we'll soon be licensed in Illinois, Texas, Washington, D.C., Ohio, and Arizona. Okay. I think, Mani, you need to update that on the slide.
Sure, sir.
Okay, yeah. So first, to start with, in the US, the laws are categorized into two segments. One is the state law, the other one is a federal law. For example, immigration is a federal law. So the same rules apply in all the states, right? Patent law is a federal law. So the same rules apply throughout the country. That means all the states. But there are certain areas of law which are state specific. For example, criminal, corporate, litigation, family, wills and trusts. These are all state specific. They're state specific laws for each of these categories. So the laws vary from state to state. So you need to make sure that whenever you have a will or a trust in a particular state, it is as per that state requirements. Okay, and also please note that whatever we're discussing here today, it's more catered towards the immigrant community. Okay, like for those who have assets which less than 2.5 millions, who are currently here in the US on a non-immigrant visa, parents abroad, having a house and US citizen kids. So these are the parameters. Like the way I developed this one is to cater more towards those who are here on H1Bs and L1s, right? And also, please note that not everything will flow from a will or a trust. So you cannot include everything in a will or a trust. For example, if you have a life insurance, right? Or maybe your 401k. So you have to designate the beneficiaries in those documents itself. So I'll give you one example. Assume that a person by name Raja got a life insurance before he got married, right? And in that life insurance, he may have had his brother or sister as a nominee, right? Later on, he gets married, and then he prepares a will. Even if he includes that life insurance in the will, it will not pass through the will, right? So you need to clearly understand what are the things that can be included in the will and what are the things that cannot be included in a will or a trust, right? So again, please stop me if I'm going too fast. I want to cover the following topics today. So if you think that I'm going too fast, we can slow down and then discuss these in more detail. First, we'll discuss what is a will and why you need it. Then we'll discuss what are the different types of wills. Then we'll discuss what is a trust and different types of trust. Then we'll discuss what happens if a person passes away without a will, right? And then we'll discuss about how to create a will and who can create a will. We'll also discuss about out-of-state wills, that is like how to handle wills for properties that are located out of the state and out of the country also. Okay, and we'll also discuss about the protections that are available for wife and children if, in case if one of the spouses does not leave any property for them under a will. Finally, we will discuss the pros and cons of going with will and a trust. Okay, so does anyone want me to discuss any other matter apart from these topics? If so, please type here and then I will include them also in this topic. Okay, so as I mentioned, wills and trust is a state-specific matter. Okay, so but for today's convenience, I'm going to discuss about the Virginia law that applies to wills and trusts. Okay, so there are a lot of misconceptions about wills. So I'm going to discuss each one of them. And after each topic, I'm going to leave the floor to any questions that you may have so that I can clear any doubts. Okay, so a lot of people call us asking, hey, I want to do a trust or a will, right? So a trust or a will, like neither of them is a perfect solution for any particular situation. Not everything, like you, depending on the situation, a trust may be a good option, and in some cases, a will could be a good option. So what is a will? So basically, a will is a written document that allows individuals to direct the way their inheritance would be maintained and divided after their demise, right? So a will, basically you will write down whatever, like the way you want your property to be divided among the beneficiaries, and also anything else that you want to include in your final wishes. For example, if you want to speak about like who gets the custody of your children, you can include that in a will, right? But you cannot include certain those things in a trust. A will typically goes into effect once a person demises, right? Whereas a trust will go into effect the day the trust is created. Okay, so there are different types of wills. Oh, I don't have a screen sharing thing, but we will prepare some slides and share it with you at later point of time. Yes, Jyoti, we will cover the topic as to how to handle wills if you have property outside the US, especially in India. Okay, we'll get to that one in a few minutes. Okay, so there are different types of wills. The main categories are living will and a last will. Okay, a living will come into picture when a person is not able to in a situation where they are not able to make a uniform judgment. Like for example, if a person is in coma, right, and if you want certain decisions to be made, then you provide that in a living will, right? So it's also called as a healthcare directive, right? So basically, if a person is not in a situation where they are, 1 second, team, I'm receiving some other request. Okay. Okay, so written will details a person desires regarding their medical treatment in circumstances in which they are no longer able to express their informed consent, right? So that is also called a healthcare derivative. Whereas a last will come into picture if a person no longer exists, right? So the purpose of the last will is to leave instructions on how to pass your property and finances to your family members and friends when the person no longer exists. Okay, a will is especially important for parents with minor children because it will allow you to appoint a guardian, right, legal guardian, or it will at least assist the judge in deciding whether a particular guardian is suitable for the kids or not. So if you do not leave your intent in a will, then it becomes a challenge, and the judge might think that, hey, the grandparents who are currently outside the US may not be, or any cousins of yours who are living in the US may not be suitable to take care of the kids or act as their legal guardian. So it is very important that you mention who you want to appoint as a legal guardian in your will. So legal guardian for your minor children. Okay, so what is the main difference between a will and a trust, right? A will actually go into effect when a person passes away, right? Whereas a trust is actually an entity that is created to hold and manage your assets for the benefit of the beneficiary. So the trust will go into effect when you are alive, right? But I would not recommend having a trust for most of the people because a trust is a good option if you have a lot of assets, right? For example, if you want to save money on what do you call the estate taxes, right? Then trust is a good option because there is no transfer of assets when you do a trust. But you cannot mention a legal guardian in a trust. So one of the main advantage of going with a trust is, since there is no transfer of property in a trust, you could avoid paying any estate taxes. But again, the estate taxes will not apply to you unless you have millions of dollars. For example, for the year 2022, there is an exemption of up to $12 million. Okay, so unless you have more than that, like, you don't have to worry about going for a trust. Okay, again, within the trust, there are two different varieties, right? One is a revocable trust, the other one is an irrevocable trust. A revocable trust is a good option unless you have any creditors who could be going after your assets. So especially if you think that there could be any creditor who could go after your assets, then you should go for an irrevocable trust. But if you go for an irrevocable trust, then even you cannot make any changes to it. Let us go through the questions first. Okay, Jyoti, to answer your question regarding handling of properties in India, right? So whenever you are doing a will, right, it should be as per the regulations that are allowed in the place where the property is located, right? So if you're having any property in India, then you need to draft the will, get it notarized at the US embassy. At the Indian embassy. Okay, there is a specific procedure for that, which we can share it with you. Okay, and then you could also get the will registered in India. In that way, you are safe. You have a better protection. Okay, so typically these wills, right? So you need these wills for India have to be attested by 2 witnesses, or you can do it by using a notary. So in the Indian Embassy website, there is a miscellaneous form that you could use to get the wills attested for the property located in India. Fully paid off to be included. No, Raj, you asked if the property has to be fully paid off to be located to be included in a will. No. See, a will is just a directive for the judge to assign the property. Like, so basically, even if you have a house, right, you could say who gets the house, but that does not mean that it will be free of any loans or whatever, right? So before, in your will, so what happens if a person demises, right? Then first thing is the whoever is handling the estate, right? They will have to pay all the taxes and they have to clear off the loans and then distribute the property among the beneficiaries. Do we need a will if we do not have any property in the US and all bank accounts are joint accounts? Good. So PD, to answer your question, right? So you would need a will in case if you have any minor children. I highly recommend having a will. And then if you do not have any property in the US and all bank accounts are joint accounts, yes. If all the bank accounts are joint accounts, then your other joint account holder will automatically get access to all your bank accounts. But what happens if both the account holders are not available at the same time, right? So in those cases, the will protect the interest for both of you. So to answer your question, I recommend having a will even if you have joint bank accounts. Does this answer your question, PD? Is everyone on mute, Mani?
Yes, sir. I think the client has messaged. Yes, great, thanks.
Okay, fine. And then allow them to be able to speak.
Sure, sir.
Santosh, I would like to recommend one thing, just to talk about will and trust, the silent features of the will and trust. Then after that, you can receive all the questions, answers, so.
Okay, fine. So, okay, this is, you want to go with who can create a will, okay, fine. So first of all, who can create a will? Any person above the age of 18. In Virginia, any person above the age of 18 can create a will. The will has to be either signed by the testator. When I say testator, the person signing the will. The person who is creating the will is a testator, right? either the will can be signed by the testator, or if the testator is not in a position to sign the will. For example, assume that somebody is completely sick and they're not able to sign the will, then another person can sign the will, provided it's in the presence of the testator and at the testator's directions. For example, if there is somebody who is on deathbed, right, and they don't have a will, they can actually direct somebody else to sign on their behalf, okay, in their presence, and that is acceptable. And very few people they know about this one. So the will need not always be signed by the testator itself. It can be signed by another person also. Okay, and permissible forms of will. So in Virginia, accepts holographic wills also. So when I say holographic will, you could just take a piece of paper and write it on it, like whatever you want to write. For example, in case of emergency, you may be able to write, hey, I want this to go to so and so person, right? So if it's a holographic will, that is a will written by hand, then it need not be witnessed, right? You don't have to have two witnesses who can attest to that will, but you need two witnesses who can say that it's actually the testator's handwriting and signature in case the will goes for probate. Is that clear? Okay. And also, a oral will regarding personal property may be made in limited circumstances. So, for example, insert like if there is a personal property, like maybe they have like some jewelry, right? Or in certain situations, oral will is also allowed. Okay. Further, contracts to make a will are enforceable in Virginia. For example, if you enter into a contract with somebody saying that, hey, I'm gonna provide so and so services to you, and that once you pass away, you're gonna like, and you'll include so and so property to myself in your will, right? As long as you have clear evidence of existence of this contract, you can. It is allowed in Virginia. Okay, then this is a question that I receive all the time. So in Virginia, electronics wills are not allowed. For example, if you e-sign a will, it's not permitted. It's not allowed. So assume that somebody has property in Virginia and they are currently residing in some other state, right? As long as the will is as per the state where they are residing, Virginia does allow it. Should we go to some questions first, or do you want me to continue this one? Okay, I will just go through the will execution requirements and then we'll get to the questions. In Virginia, a will must be signed either by the testator or by another person in the testator's presence and the testator's direction, right? Further, any will has to be attested by two witnesses, two competent witnesses, okay? And these witnesses, unless you have to be available in case the will goes to probate, okay? Or if you want to avoid the situation, then I would recommend getting a notary also done at the same time. Okay, there is a specific language that needs to be included in the notary so that the witnesses need not be present for the probate. Right, so that is actually there is something called a self-proving certificate that the testator and the witnesses can sign in front of a notary, so that they don't have to have any witness to be present in case the will goes to probate. So now we'll go to the questions. Good. Pension. We'll start with pension. There are a few agents recommended to get will and trust using NetLaw, etc. Are they worth it? Okay. So as I mentioned, right, not everything fits everybody, right? So the wills that are typically available online, right, they are catered more towards the need of a typical US citizen, right, who have settled here, who do not have a lot of connections abroad. Like for example, and the requirements for a typical non-immigrant would be different from the requirements of a US citizen, right? And these bills that you find online are more catered towards the US citizens, right? For example, like you may have a different requirements. You may want to be able to mention who gets custody of the child, right? Legal custody. So those things typically would not be present in these drafts that you find online. Of course, they will be able to make modifications as per your request. Panchal, does it answer your question?
So, sorry, can you explain what is the difference when it comes to a citizen or a like immigrant?
Yes. So if you have an immigrant, right, you have a different requirements. Okay. Number one, what is it that you're trying to protect? Here, even if you do not have a will, okay, the property goes through to your spouse and kids through interstate succession. Right? When you say interstate succession, the government does not take the property. It will just flow to your spouse and kids as per the state requirements. Here, what you're trying to protect is your intentions as to who gets custody of the child, right? Because that is the most important thing that you're protecting here, right? Those are the things. And then about your, about who, like for example, if you want some things to go to your parents who are residing outside the country, right? Then how do you identify them in your will? Or maybe you want some properties to go to your siblings. So those are the things that are typically not included in the regular wills that you find here. Does it answer your question?
No, what found is different. We can add all those things in the regular will also, like a basic will.
Yeah.
I don't see any difference. So when we are filing for a citizen or an immigrant, because it's
so
all.
Typically, I'll give you a small example. Okay. Yeah. So whenever we draft a will, right? So for example, if a person says that, hey, I have a brother living in India, right? Or I have a cousin living in India. So what we try to do is we try to clearly identify the person. We include their copy of their passport or whatever, so that there is no question about who the person is. Do you understand the difference?
No, can you repeat?
I'll give a small example. Assume that there's a person by name Raja, right? Mm-hmm. So he wants some of his property to go to one of his cousins or brother, right? So he will mention their name and they are assuming that they are outside the country, right? How do you make sure that the person is correctly clearly identified?
That's up to you, right? Because you are giving your assets, so you make sure that you are putting a correct.
That is true. So we try to include all those things in the will so that there is no ambiguity. It is the same will, whether you do it outside or anywhere, right? So even you could write a handwritten will also.
Okay.
Hello, I have a question.
And also, when we draft the will, we make sure that there is no requirement for the witnesses to be present in the court when the will goes to probate. Does that make sense?
I have a question. Can I ask?
Yeah.
Yeah. Once the will is made, it has to be registered, right? I've got that. But if suppose there is going to be a change in the will, like after 6 months, I feel I want to change something in the will.
Yeah.
So even the succeeding will has to be registered again?
Yes, yes. You could either do it as a codicil, which is an addition to the will, or it's better to do like register it or include the codicil and then register the codicil.
Does the same hold in India too? Suppose a will has been made by the parents in the daughter's name, and then the will is registered at the registrar's office. But the succeeding will, suppose there's a change and the person says that's fine. So does that hold the same thing?
Yes, I recommend getting it registered.
But what if it's not registered, the succeeding?
Then
and the contents are the same.
Yeah. So you'll be opening yourself for the litigation. Because see, typically what happens is when the will goes to probate, right? Unless there is someone else who is contesting the will, you should be fine. But if someone else is trying to contest the will, then the issue occurs, right? So for example, maybe your parents left property to you. And then later on they change, like they have another document which is dated with the later date where they leave the property to someone else, right? So that person could litigate this will.
No, but if the property is to the same person and everything is the same,
then we should be fine. Then you should be
everything, there is everything written and the property is nominated also apart from the will at the society office.
then
It should be fine.
Then we should be fine. Yeah. And then also you can include a non-contest clause in the will. So for example, you could say that you could include a clause in the will saying that, hey, if, for example, you have 3 beneficiaries, right? Then what you could say is, hey, if any one of the beneficiaries contests this will, then they will not get anything from the will.
Okay.
Like, for example, if you have 3 kids, right? So you can say that, hey, this one, kid number 1 gets this one, kid number 2 gets this one, kid number 3 gets this one, right? And then you include this clause and say that, hey, if somebody contests this will, they will not get anything.
Okay.
Hello, I have a question.
Yeah.
Thank you very much.
So once we register this will, right? Like as you said in Virginia, they don't accept E.
No, you don't need to register. It's not mandatory.
No, I mean like for will to have a physical document or anything, do we need to make any monthly payments, or is this like one time?
No. See, that is the difference, right? So for example, if you have a trust, right? If you have a trust, the trust is like an entity. So whatever, like for example, the trust is like an entity, it has to file its own tax returns, everything. Whereas a will is just a document, right? You don't have, there is no monthly maintenance or anything like that for a will.
Okay, it's like one-time payment.
One-time thing.
Okay, and other question is, let's say my kids are citizens and I'm an Indian citizen, right? Like the properties in India, we can even include that in the will, saying that it should.
No. So for the properties in India, you have to go through a different procedure. So you'll have different wills. Okay, so you'll have a will for your properties in the US, right? And then you'll have a separate will for your property in India.
Okay, for the separate will for the property in India, you could still assign that to the minors, or?
Yeah, you could still do that. But it should be asked for the, for example, if you have minor children, right? Then you could say who would be the custodian of the property until they turn certain age.
Okay.
Does it make sense?
Yeah. And usually when I open my bank accounts or anywhere, right, the nominees, they don't allow to add the minors, right? Like if I want to add my kids. So even in the will, we need to mention, it will be recorded that only after 18 years, they will get the custodial, something like that.
Well, see, this is what happens. So if the person is a minor, right? You need to clearly mention who is going to manage the assets until they turn major, right? If not, the court is going to appoint somebody.
Okay, got it. Yeah.
Okay. So in your will, you will say that, hey, if something were to go happen, so and so person will get the property. Like my son or whoever will get the amount in his bank account, right? And so person will be acting as a custodian until they turn so and so date. Age.
And, yeah, I think I just got, sorry, one last question, because we are writing the will here, because the properties in India are under the Indian government jurisdiction, right? The will which we are writing is universal, like even it will be applicable for the Indian property.
See, when you say will, it's pretty much, see, most of the stuff is the same everywhere, right? So you basically, you're writing, providing your intent. Okay, you have a beneficiary, you have an asset. Okay, the only thing typically that differs is an attestation requirement, right? So they will, like each state or each country would have a different attestation requirement. And once you go through the process at the Indian embassy, then that requirement will be met.
Okay.
I think we have Satish and Chaitanya who raised their answer.
Okay.
Sir,
Yes,
this
sir.
is Chaitanya.
Mhm.
I earlier asked a question. So, what if I have a sibling? Then do I still need? Say my kids are American citizens, and whether I'm a citizen or green card holder or a non-immigrant visa, staying on non-immigration visa. Can my sibling who is living in this country, irrespective of what visa or immigration they are in, can they be legal guardians in case if both parents pass away?
Yes, but not automatically. That's what I was trying to say, right?
Okay.
You need to, like, see, you should not leave this up to the judge to decide whether your siblings are or your anybody in your extended family is the right person to take care of the kids, right? So if you clearly mention your intent in the will, right, then the judge will probably accept it.
Sure, but without the will, the judge will decide what to do with
so
the
they
children, right?
might decide like, hey, it will be tough for the judge to decide, and they can then put them into foster care.
Is this same rule applies for every state?
No. But most of the times, this is what the judges would do.
Okay, got it. Thank you.
Right?
Next we
That
have
is the reason why I say that, hey, you need to. So, for example, typically what we do is, hey, we mention that, hey, if something were to happen to both the parents, right, then so and so person gets the custody, right? So if they say that, hey, we want the grandparents who are currently in India, right, to take care of the kids, right? Then we'll also include that, hey, for some reason, if the judge, if you are not able to get the custody of the kids, then so and so person gets it. So we'll give them multiple choice, like different choices, right? So that at least one of them will get it.
Hi, got a question for you.
Thank
If
you.
we got a rental property in USA, do we need to transfer the title of the property to the trust that we are creating, or can we hold it on our individual name?
I'll tell you, I'll get to that one. Okay. So
Okay.
what happens is when you create, for example, a trust is a different entity, right? A trust is like a company, okay? Okay, which will hold the property for the benefit of these beneficiaries. For example, you could create a trust and say that, hey, we are creating this trust so that it will be used, for my kids' education, right? And then you will put in money, all the assets into the trust. So in your case, you will put the rental property in the trust, right? I'll give you the difference between what happens if you put in a trust and a will, right? The same rental property, assume that we put in a will, right? So when a person passes away, right, then the property, if you're putting in a will, it will transfer from you to to your heirs, right? Whereas if you put it in a trust, it will remain in the trust itself. But the heirs will be able to enjoy the property. Does it make sense?
Satish, you can go
Makes
ahead.
sense.
Yeah.
The-
So Satish, if you put the rental property into the trust, right? And then you don't even have to distribute it for generations. The trust would still continue. Right? So
If you're
Hello.
putting the
Hello.
Satish, go ahead.
yeah, if you're putting the
Hi. Please go ahead.
yeah, when we wanted to refinance, or else like let's say there is a landlord and a tenant issue, and then like we wanted to file a case on a tenant or evict the tenant, those scenarios like we are getting into troubles. Like that time, like we have to like go via the lawyer, and like the landlord was not able to do it directly.
Yes. Yes. So if since a trust is considered as like a corporation, right? So now you have to hire an attorney to represent it.
Right.
Yeah. So that is like, as I said, right? If you have a lot of property and all that stuff, then trust is a good option. But for a common, like for a typical H-1B visa holder, I would not recommend a trust. Okay. There are multiple issues with this part. Number one, you have to register the trust. Okay. You have to file the tax returns every year. Right? Because now your trust is making income.
Right.
From rental property, right? So you have to file separate tax returns for your trust. That's an extra expense.
Okay.
Right?
Right.
And you're not getting any further benefit, right, out of it, right? By paying the extra money. Instead, if you had it in your will, you would have, everything would have been in your tax returns. There is no extra filing for that. Okay. And even if somebody passes away, right? They say that, hey, it takes time to transfer the property if it's a will. That is, it's not a complicated process, right? If somebody passes away, all you need to do is just take the will, submit it in the court. They will be able to transfer the property. It's not a complicated process.
Got it.
Right? If the will is properly drafted and attested, it's not a complicated process. It's a simple way. Like I know a lot of people think that, hey, if somebody passes away, if you have a will, then it goes to the probate and then it'll take some time to get the property, right? But it is not a complicated process. All they got to do is just submit the documents in the court and they will be able to transfer it. Instead of paying yearly for the trust, I would recommend just doing a will. Again, if you have a lot of property and all that stuff, then trust may be a good option.
Satish, go ahead, Satish.
Hi. Hi.
Yes.
Thank you. I have one question related to the will. So my kid is US citizen and we are like non-immigrant visa, and my parents has like typical like Indian citizens and they have B1, B2 visa. So in this scenario, like if something unexpected happens as parents, so instead of going kids to the child protection care, so my main question is how to avoid that scenario. Can we need to? We want to keep my parents as a guardians, and my friend, one of the friend in US as another guardian. So in this scenario, what is your best suggestion?
So what
to keep?
happens is, yes,
yep.
In your will, you clearly mentioned that, hey, if something were to happen to both the parents, then the grandparents who are currently living at so-and-so location, you want them to be the legal guardian, right? But what happens is, after you, it's the state who has authority over the children, right? So the judge will see, hey, if the grandparents are capable of taking care of the kids, right? If they are, then they might allow them to be the guardians. If not, they'll at least look at the second option, right? So now that you have mentioned about your friend who is currently living in the US, most probably they will give the kids to, like, they will appoint your friend as a legal guardian. Instead of putting them through the foster care.
Yep. That's my main concern. Yep.
So typically what we do is instead of using just one family, right? I try to include a couple of families because who knows, maybe anything to go happen to one of the family, or maybe they have been charged with some criminal offense. So we don't want to take any chances. So I would recommend mentioning at least a couple of families who can take care of the kids.
Perfect. Yep. Thank you so much.
You're welcome.
Gopinath Kola can go ahead.
Hi, can you hear me?
Yes, Ruchi.
Gopinath, please go ahead.
Can you guys hear me? I think
Yes.
Okay. I'm a green card holder. I have a couple of kids. One is Indian citizen, other one, the little one is born here. He's a US citizen. So first question is, if I write will, my brother is also in US, but he's on a H1. Can I put him as the guardian instead of my parents who are in India? That is my first question.
Yes, you can.
Okay, and
That is
second,
recommended too. That is
sorry?
actually recommended. That it is actually recommended.
To keep someone who is in India, in the US. In the US, okay. And I have a house here which is still under mortgage, but I have heard your previous answer where your recommendation is to put everything in the will, and we don't need a trust, right? Okay, so the overall only the will suffice me if I don't have multiple properties across and all.
Yes, if you do not have a lot of property in the US, right, then I would recommend just doing a simple will. At least that will safeguard your interests.
Got it.
Right?
Got it.
So the only reason why I say that is because if you have a trust, then you have to maintain the trust, and then there are different challenges that you'll encounter. Right?
Got it.
And your
me and my wife, we both can write one will, or we need a separate will?
No. A will is specific to that particular person. So you will have a separate will, your wife will have a separate will.
I see. Okay, we both need to have a separate one. Okay, and one more question regarding the will. Like, do I need to, after notary, do I need to register it somewhere, or it just?
Not necessarily.
Okay, and do I need to send a copy to the person whom I'm not nominating as a guardian?
Yes, just make sure like somebody just make sure the will is available in case somebody needs it.
Got it.
Yeah.
Thank you so much.
I had a question regarding that will, which I just spoke. Now, if the witness is in the will is identically same, which was the last will also, and all the properties going by the parents in India to their daughter is everything is same. But the witnesses who had signed in the presence of the mother are no more, are deceased. Does that affect?
Yes, so that's why I'm going to give me 1 second. Actually, I'll tell you exactly. There is something called a self-proving certificate. Okay, so wherein the testator declared in the presence of the notary and witness that the instrument was a testator's will. So we'll put in certain clauses, right? So we'll say that, hey, the testator declared in the presence of the notary and witness that the instrument was a testator's will, that the testator willingly signed the will or directed another person to sign the will in their presence, that the testator executed and acknowledged the will as a testator's will in witness's presence, and the witness signed the will in the testator and each other's presence. So basically there are two testators, right? So both of them will put in certain language so that it's instead of them coming to the court, now we are putting all the language in this self-proving certificate and getting it notarized. Right? So once we do that one, then there is no requirement that the witness has to be present in the court.
Oh, okay. All right. Now, other thing is, now if there's a property in India which one wants to sell it, what is the modus operandi to get the, after selling the proceeds to US? How does one go about doing that?
Well, that is a complete different topic. Actually, I recommend that you speak to your CPA regarding that one.
Okay. But is there a procedure to like a guideline or an outline as to how to, like from where to start.
Okay. I know there are certain NRO accounts and all where you can transfer the money, but I'm not too familiar with that area. So
Yeah. No, this is not the liquid cash, but if there's a property, the immovable property.
okay,
Like,
so you have an immovable property in India, you dispose it off,
yes.
right? And then you pay the necessary taxes,
Okay.
right? And then you should be able to transfer the money to the US. But again, there are certain RBI requirements which limits the amount of money that you could transfer from India to US.
Yeah. Yeah. Correct.
Excuse me, I have a question about.
Sure.
So you said that it's not required the trust always, but everything goes to probate process, right? Even though if you have a small house, whatever, doesn't matter which visa. That's what I was researching it.
I'll tell you. So when you say probate, right?
Yep.
Okay. I'll tell you what happens. Okay. I'll tell you what happens if you have a will. I'll tell you what happens if you have a trust, and I'll tell you what happens if you do not have anything.
Okay, thank you. That's
right?
good.
Okay. First thing, assume that a person passed away without a will or a trust, nothing. Right? Then all his property will go through what is called intestate succession. Right? So basically it's a probate, right? So what happens is everything, like then you, like somebody will submit a document in the court saying that, hey, so and so person passed away and these are the assets that he has.
Okay.
Right? Then what happens is typically in most of the states, all the property goes to a surviving spouse.
Yep.
Okay. In some states, the property goes to both surviving spouse as well as children.
Yep. Okay.
Right? In case neither, if the spouse and children are known do not exist.
Okay.
Right? Or if they are, then it goes to the other heirs. When I say other heirs, then it goes to the parents.
Okay.
Right? It's not like the government is going to take away the property unless they are not able to find any heirs. Right? That's when the government could take the property. But as long as there are some heirs, so for example, grandparents, so parents, if the parents are not there, then it goes to the siblings.
Yep.
Right? So there, yeah. So to answer your question, even if a person does not have a will,
okay,
the property will go to their heir, but it does not go to the heir in the way they wanted it.
Correct.
Right? So that is the reason why you have this will.
Yep.
But if the bank accounts are joint name and the property is joint name, then and if a will is not made, then it be contested.
The property automatically goes to the other joint. If it's a jointly held property, right? Yeah. So if it's a jointly held property, one person passes away, the other person gets everything automatically.
Yep.
So nobody can contest that. No friends.
Nobody can contest it. No, no. And also there are certain other things too. For example, if you have a life insurance, right? Even the life insurance will flow directly. It doesn't go through the will or a trust.
So what happens if
even the 401k too?
Sorry to interrupt, but my question is, let's say you have a house in a giant, but still both are gone, but the kids will not get directly. It has to go to probate, right?
So that's what. So if both the joint holders, like if both of them are gone, right? Then what happens is it goes through their estate. Right? So assuming then there is a survival spouse statutes and all.
Yep.
Says that if one person passes away and if the spouse is survived for a certain period of time, like then the other spouse gets everything.
Yep.
For example, I'll give you a small example. Assuming that the survival statute says that, hey, one of the spouse has to survive for at least 36 hours, right? Then assume that both Raja and Rani, they hold a property jointly. Raja passes away, right?
Okay.
If Rani does not pass away within 36 hours, then everything will go to her estate.
Yeah.
Right? then the property will be distributed as per her will.
Yep.
Okay. Whereas if Rani passes away within that 36-hour period, right? Then if both of them are considered to be to have demised at the same time and have the property, like they will get each of them will get half the property. So half the property will flow through Raja's will, the other remaining half will flow through Rani's will.
So that meaning all this has to go through the court proceedings, but generally what I heard, it is like it may take between 3 months to 3 years, depends on state load. It can't take
see, that
money
happens
also, right?
if somebody is contesting the will.
Okay, how long it take and how much is cost, sir? General.
It does not cost. See, if it is, I'll give you a small example. Okay. Assume that it's just like if for a typical non-immigrant, right? What would they have? They will have a house, a car, bank account, and maybe 401k and all that stuff.
Correct.
Right? Life insurance, 401k. Life insurance and 401k will automatically flow.
Correct.
The next thing would be the house. Okay. And so for those things, right? All we need to do is just submit the death certificate. Okay, and a copy of the will.
Okay.
As long as there is nobody contesting the will, like for example, there is no one else coming, like for I'll give you a small example. Assume that the will is written, like will says that everything goes to the spouse.
Okay.
The other spouse, right? Then there is no one to contest the will.
Correct. That's true.
Right? And it so happens that, for example, if somebody does not leave anything to their spouse or children, right? So then there are survival, like there are certain statutes which gives some protection to the surviving spouses.
Correct.
Right? For example, assume that Raja has $100,000 worth of property, right? And then he gives the whole $100,000 in his will, like he writes a will statement that hey, the whole 100,000 goes to my parents or my brother or somebody else.
Yeah.
Right? Then what happens is in those cases, the wife, who is a surviving spouse, can contest the will.
Yep.
Right? And then she'll be eligible for at least the elective share. For example, in Virginia, it's 50% of the estate.
Oh, is it community property state?
Yeah.
Oh.
Whether it's community property, like they still get the elective share.
Oh.
Okay. And there is something called homestead allowance. They get $20,000 homestead allowance. Also, they have certain exempt property, for example, the personal items, household furniture, appliances, cars. Like there are certain things that are also exempt, so they get it automatically.
Okay.
Okay. They're also eligible for family allowance during the estate administration.
Okay, sir. Unfortunately, we have to intervene because it's already 8 p.m. and we have 9 more questions. So I'm going to take on the questions and then I'm going to move you guys back into the audience. Please keep your questions brief and please stick to one question. Again, if you have any more question, we will have a follow-up session and you can always email us back at info@somireadylaw.com.
Hello, I have one question.
Yeah.
Excuse me, sir, we are going in order. Sorry, can you just stay on the line? We are going in order. Mr. Sai Krishna, can you please go on next?
Hey, thank you. Hello, Santosh Garu. I have just a question like, so these days, like I've seen so many of my friends going through will and trust process, either through online services like NetLaw or maybe through the law firm. So what is how much is this important for a person like me who came to USA from India on H-1B, and there are a lot of technical coming to technicalities, like I see like healthcare, power attorney, or maybe like living will. I mean general power of attorney, like maybe something else like living trust kind of stuff. So because for me, like I don't have much properties here for sure, and like I have only one house and a kid. So what is really important, because there is so much of miscommunication.
What is important in your case would be a living will and a last will. Okay. living like last will, basically all it says is, hey, if something were to happen, so and so person gets so and so. Okay, and if something were to happen to both the parents, then the kids, so and so person gets the custody of the child. Right? Living will, if for example, if a person is in, like if a person is in coma, right? Somebody needs to be able to make a decision on behalf of that person. Right? So again, living will, I know I heard stories wherein some people repented having a living will because what I assume that a person is in a deathbed, right? Or maybe they're in a coma. So they may have written a living will saying that, hey, if I'm in coma for 18 hours or for 2 days, then maybe you should remove me from life support, right? If they have not written that one, they would have probably kept them on life support for much longer time.
Got you.
Right? So it is a personal choice.
Okay. And
right?
the
so
same goes with last will and
give
testament.
you an example. Maybe your spouse, like your well-wishers or spouse may not like that fact that you have a living will. Because now they are not able to make a decision. Does it make sense? Like in this situation, right? So maybe the spouse wants the person to be kept on life support for more than 48 hours, anticipating that he may wake up, right? But now that they have a living will saying that if the person doesn't wake up in so a certain period of time, they should be removed from life support. So it's what should I say? If you ask me personally, I would have a last will or not a living will. Personally, again. But having a living will is also a good option.
Okay. Yeah, because I've seen
because
so
some
many
people
things.
they don't want to go through the pain.
Yeah, that's true. Like see, that I was just only looking the how much we are complicating
So,
our lives.
Yes.
Because like
so if
so many documents
person
they are
is over, assume that if a person is over 60, right? Then I would think of like if once I reach that age, then definitely yes, I would think about having a living will. Right?
Yes.
So that's why I'm saying like not everything fits everybody. Right? So if I were to be in your shoes, I'd probably have a last will. That's all. I would not have a living will. But again, don't hold me to that one. Maybe it's a good idea. Like who knows? It depends. It's a personal choice.
Okay. And that there comes the for power of attorney like healthcare or general.
Same thing. It's pretty much the same thing as the living will. Pretty much. They're yeah.
Okay.
Power of attorney is basically what you're saying is, hey, if I'm incapable of making a decision, so and so person, I'm authorizing so and so person to make decision on my behalf.
Okay. Thank you, Mr. Sai Krishna. Now we are moving on to Mr. Ramana. You can ask your question.
Hi.
And Sai Krishna, one thing. So even if you have a living will, typically I would recommend that just give it to someone who you love the most, maybe to your spouse, so that she can use it only if required.
Got it. Thanks.
Okay. Yeah, but yeah.
Thanks.
Yeah.
Yeah.
Thanks, Santosh.
Yeah. Almost
hopefully you
similar
never have to
questions.
use that one, but I'm just.
Hi. Almost similar question. How important this will and trust is required for the H-1B immigrant who their kids are also Indian citizens? If something happens to both the parents at the same time, what will happen to the kids?
Well, the kids will
without will and without will.
Yeah. So the kids are not US citizens, so the kids will have to leave the US.
Okay, so that means
so most
for
of these
them
things will not even apply to you.
Okay, for them will is not required in that case.
Then I would not say that will is not required. It is required for other reasons.
Okay, I mean last will is not required, only living will is required in that case.
Well, last will also required if you want somebody to get your property, whatever the property that you have in the US.
Okay. Okay.
But it is not.
Yeah. And one thing, without
if you
will
don't have any
and trust,
property, no US citizen kids, nothing, then maybe it's not required.
Okay.
Right? But again, it is always best to have a will. to carry out, like, for example, if not, everything will be in the air, right? Like you not know what will happen to your assets or whatever.
Okay. Yeah, and the another question is, earlier, one other question you not answered it. I mean, how much time it takes without, with will or without will in the code, and how much we need to pay as a, fees or payments or whatever, attorney fees and all, in case if you don't have will, and if you have will.
Yes, if you have a will, right?
Yeah.
And if there is nobody contesting the will,
yeah,
it is a pretty simple task. Okay, you just take the will, take it to the nearest, like the courthouse where the property is located. You will submit, the will as well as the property documents and the death certificate. Okay, and pay a minimum, like whatever is the fee.
Yeah.
Right, and then they will put it for probate.
Yeah, what is the approximate date without contesting? Approximate time?
You're looking at 2 months or so.
2 months, okay.
Yeah.
That's a with will.
It will only happen if something bad were to happen, right?
Yeah.
So it is worth waiting for that much period of time. It's not an expensive process. You could do it yourself also. You don't even need to hire an attorney for that.
Okay. Is it for with will, you're saying?
It is with will.
Okay. Without will?
Without will, so what happens is, now you have to prove who are the heirs and all that stuff. Right?
Even
for that purposes, you may have to, you may be able to do it yourself.
Sir, unfortunately, due to time constraints, we have to move on to other participants. We have a lot of questions. So if you have any questions, please email us at info@somireadylaw.com and we'll get back to you immediately.
Okay, thank you.
We are moving on to Dan.
Let us conclude in 2 minutes.
Sure, sir.
Yeah,
then maybe Dan, Sarala, and Cherish, you can quickly ask your questions in one go, and then we can wrap it up for today.
Yeah, thanks. Dan here. Can you guys hear me?
Yeah, Dan, go ahead.
Yeah, thanks for sharing the information. I have a broader question, but probably you can elaborate. So you said trust is a costly affair. So if I can I have a will and mention in the will that if I pass away, open a trust with all the properties from the will?
Yes.
And manage the trust.
Yes, you can do that.
Mutual funds, life insurance,
You
everything.
do vice versa also. Yeah, you can do that.
Okay, and so will they have authority to sell the things in the trust, like the kid, whoever inherits?
No, so
my kid
typically,
inherits that.
what will happen is, but the trust should be in existence. So for example, assume that there is a trust, right? So you will say that, hey, whatever something were to go happen, then this property, this $100,000 will go into that trust for this benefit.
Oh, so trust has to be open before the
I recommend open, because see, if not, it becomes a challenge. You need to clearly mention who the trustee would be, what are the what is the intent of the trust and all that stuff.
Okay, got it. Thank you.
Okay, or you could say that, hey, this so and so property should be used for so and so purposes.
Yeah, thank you, Dan. And then Sarila ji, you can.
Mani, I think Jagdish is waiting for a longer time. Could you please ask Jagdish to ask his question?
Yeah, sure. I don't see a raised hand. Sure, but Mr. Jagdish, go ahead. Mr. Jagdish?
I have a quick question. Can I ask?
Just 1 second, Mr. Ramesh. We are going in order. Ms. Sarala, you can go next.
Yeah. So what my question is like, will you said it is even though if it is not there, then all the assets will go to the spouse, right? And but if both the parents are gone, then who the kids will go to and the assets will go to? They will be like on.
I'll tell you.
So
if they don't have a will, right? Then what happens is the court will appoint a guardian for the kids.
Okay.
Okay, guardian for the property as well, like and the guardian. So sometimes, depending on the children's age, maybe like the court will, for example, I'll give, when both the parents die, the child is said to be an orphanage, right? There are different outcomes in this situation. It depends basically on the age of the child, their mental status, right? If the child is very young, then they may put in foster care. Or they will be like adopted by another family member. Okay, it is like at the discretion of the court to decide what will happen to the kids.
Yeah.
But the judge will look at everything. Now you are actually like when doing all the stuff, right? The more amount of time that you have to spend in the court, you're incurring all these attorney fees and everything.
Yeah, yeah.
Right?
That's
Instead, if you write it clearly in the will, saying that hey, if something were to go wrong, so and the person gets it. So and the person is my cousin. He's like he'll take care of this, right? And as long as your cousin agrees to take care of the kids and be their legal guardian, and then if they don't have any criminal background, or if they are like if they are financially sound and everything is good, then the judge does not have any problem in giving the guardianship to your cousin.
right. So it's a lengthy process, and somebody has to go to the court.
If it is already included in the will, it's that's why I highly recommend everybody to have a will, and then clearly indicate all your intentions in that will.
Right. Thank you so much.
Mr. Ramesh, you wanted to ask a question?
Yeah, my question would be pretty quick, Santosh Garu. So I stay in Washington, Seattle. So in case if you want to write a will, right, will I need to reach out to the local attorney here, or will you be able to help me out?
Well, I'm licensed in Washington State also.
Awesome. Then I'll reach out to you on
But
your email.
yeah, I need to look up the requirements. It should be pretty same, pretty much the same. But definitely, yes, we'll be able to assist you.
Sure, sir. I'll reach out to you on your email, sir. We'll talk there. Thank you so much.
Thank you.
Thank you, Mr. Ramesh.
I wanted to ask you whether the property in India can be included in the will which is made in the US for along now that if a person is living in US.
Yes, so but you'll have two different wills though. For your property in India, I recommend, because so now you have to go through the separate attestation process, right? So that's why I like you should have separate will for your property in India and separate will for a property in that in Virginia.
Okay.
And it gets executed right here in US.
Was it?
It will get executed in US if they make two different wills. If two different wills are made, like one for property in India and one for here, it will carry weight here, right?
I didn't understand your question. Can you repeat again?
It'll be can it be executed here if two wills are made?
Yeah. So basically, it will be like for the will that includes your Indian property, it has to be executed at the Indian embassy, right? For your the will for your property in Virginia, it could be executed anywhere in Virginia.
Cherish.
Thank you.
Or any other state too, as long as they meet the requirements.
Hello.
Setting up a living trust and a will for a family.
What's that?
How much do you charge for setting up a will and a trust for a family? Like a husband and wife?
For a will, we charge 500 per person.
500 per.
For a trust, it depends, because depending on the amount of property that you have, because it's not just creating the trust, right? Once you create the trust, you have to start transferring all the assets to the trust. Okay, so typically you will end up paying like $1,500 or so for the trust, right? That's why I said like because the will do most of the work that you need to be done.
So, and once will and trust is registered, like, how often or what is the maintenance for that? Like, renewing it? Or...
So for a will, there is no maintenance. Whereas for a trust, you have to file the tax returns, everything every year.
Okay. So when there are like major changes, then how do we include those? Like maybe property buying or some other major changes that were
So
not mentioned
in the will
earlier.
or a trust? Which one are you speaking about?
Cherish, you had a question?
No.
Yeah.
I think
Oh, my question was towards the will.
okay, so if it's a will, right? So if for example, if you purchase a new property, right? Then what you could do is you could add a codicil to the will, or you can just draft a fresh will. Okay. Whereas if it's a trust, right? The trust can either sell and buy the property, right? So basically, if you are selling the property, then the trust will sell the property.
Okay. So for those amendments, how much does it charge down the line?
For a will?
Yeah. Yes.
If it's a small one, then we probably charge like $100, $150 for these amendments, depending on how much time we have to spend. Because since we already have all your information, it will be easier.
Okay. Thank you.
So for a wheel, it's like a $500, and for a trust is a $300.
No. It's not $300 for a trust. We charge $1,500 for a trust.
Okay, I see.
Yeah.
And in a trust, you say like
It's not just having a trust. For example, assume that I'll give you a small example. Assume that you have property in some county in Virginia, like South, right? So it's not just creating the trust. We have to transfer the property to the trust also, right? Which might require you to go there and then do the transfers.
Right. Okay.
Yeah.
And you say
It
like
could be
we have to
expensive.
file a return,
Like if
right?
you ask me the price wise, and it's much expensive for a trust compared to a will.
Okay, I see. And you say like we have to file a return every year for tax return.
Yes. For example, if you have a trust, for example, the other person, right? He had a rental property, right? So whatever the rent they are receiving, it's the amount that the trust is making.
Okay.
Right? So the trust, since it's making money, they'll have to file a tax return for itself.
Okay, but the CPA has to do that, right?
Yes, the CPA has to do that. You have to pay the CPA. Like that's the reason why I said, like, if for a typical H-1B visa holder, I would recommend just doing a simple will.
No, I'm talking about the
because it is economical and it will cater to most of your needs.
Right, thank you.
If trust is not making money, so still do we need to do a tax returns?
That's a good question. That's a question for your CPA.
Okay.
Because it's an entity by itself, right? So you still have to file something.
Okay, thank you.
Yeah.
When we are
But the trust is creating with SSN is ID, right? So I don't think so. You need separate filing. Am I right?
For which one?
The trust, whatever.
No, the trust will have a separate ID.
Yeah, but typically you put it in SSN as ID, that will valid.
No. You cannot do it that way.
Okay. You need to get the EIN number. That's what you're saying.
That's the it's a separate ID that you have to use for the trust.
Okay. Thank you.
When we want to
When you have separated, definitely you need to file the tax. If you don't, then you don't.
Yeah, I think we already crossed the time.
And I have one last question. If we have a trust and if we don't want to maintain for some other reason, is there we can do that? Like we can cancel the trust?
So there are two different types of trust, right? One is a revocable trust. The other one is an irrevocable trust. If you create a revocable trust, yes, you can always dissolve at any point of time. You can make any modifications to whatever you want to do.
Okay, is there any process or how much charge it involves if you want to modify the trust or if you want to totally?
All you got to do is just transfer away all the assets from the trust.
Okay, so again, all recording fees is for all the assets.
Yeah.
Okay, so for any simple modification, like if you have a rental property, lease renewal, lease, or like refinancing, for everything also you need to pay? in the trust, you need to pay the recording fees in the trust?
Yeah.
Any modification to the rental property or whatever it is, still you need
I didn't quite
for every
understand the
time whenever you need to change like a tenant, or whenever you want to, if you want to sell or if you want to refinance the rental property also, you need to pay every time the charges for the registration or whatever changes you made in the trust?
No. So see, you would only do that for transferring the ownership.
Okay.
So when you buy a property, you transfer the property to the trust.
Okay, so in case of
It's
buying,
not for renting and all. Yeah, for those you don't have to.
okay, only for buying and selling,
Buying
that
and
means
selling,
you're
yes.
transferring. Okay, got it. Thank you.
Okay.
Yeah, I have one question regarding about the guardianship. So I was reading the will, and I came to know that the guardian having the authority to sell the property, and he can able to reinvest, he can able to invest, and he can do a lot of modifications on the properties when there is a child is minor. So how much is secure when we give an authority after our parents' death? How much is secure as a will? Because it's a will itself saying that the guarantor is having authority to do whatever he can.
Who you trust. Okay, you need to clearly identify the guardian who you trust. If not, the court will appoint a guardian.
Okay, I was recently watching a movie I care about in Netflix. It has a lot of loopholes in will. I think everybody I was suggest to watch and see how the system works in US.
I know that is the reason why I say that you have to clearly mention who will be the guardian, who will take care of everything. So you need to have a trusted person who can take care of all these things for you.
But can't we able to modify the will process stating that they have no authority to sell
Yeah, you
or
can mention
reinvest
that.
or
You could mention that. Right? You can mention your intention in that.
Oh, it's not mandatory.
No, you can mention that, hey, this house, the so and so person will have to rent it and then use only the proceeds. They cannot sell the house.
And I saw that there is an maintenance fee, and they have authority to take the maintenance fee, whatever they like from the
Yes. So
property.
if there is for example, if the court appoints a guardian, right? So then the guardian can charge their fees, their hourly rate.
So who validates that? If some they have charge of $100, but they take $10,000 for
They
the
just submit the
maintenance.
record to the court.
Or court will validate.
That is the reason why if you have someone who you trust, then maybe you should just mention their name.
Okay.
What was the movie name?
The same thing with the trust also.
I care about movie in Netflix. You need to watch. Everybody should watch on this.
Okay, thank you.
Okay, I think we should conclude the session now.
Somiredi, one quick question: do you accept Hyatt legal plans?
We don't actually right now. We are not accepting any legal plans.
Okay.
Because see, we are this will thing. We are doing it as a part of the community service, and the amount of time spent on these, the charge is very nominal.
Okay, thank you.
Where is your office located?
In Ashburn, Virginia. I'm based out of Ashburn, Virginia.
Santosh, you take care of Texas also?
I will be licensed in Texas in about a month or two.
Oh, last week we met over here.
What's that?
Do you do for
Last week
Minnesota?
we met in IT sir meeting.
Yeah. So I'll be licensed in Texas in a month or two. So apart from immigration, I do handle a lot of litigation, corporate and employment law matters, especially dealing with these non-compete agreements, non-solicitation agreements, employment law, wage theft. So these are the areas that I practice.
So were you practicing in India or were you a civil engineer there?
Yeah, I'm an engineer from back in India, but we have other staff members who are licensed in India.
Okay, so you did all your law studying in here in US?
Yes, I did my JD here.
Okay, so you changed fields completely. Okay.
Yes. Since I did my JD here, I'm able to get licensed in other states.
You're licensed in Maryland, right?
Yes, I'll be taking. Yes, I'm licensed in Maryland too.
Yeah. Now my question is, you're in Ashburn, Virginia, and I'm in Maryland. Now, suppose you must be traveling a lot as you're licensed everywhere. Then it will be very difficult to get hold of.
I don't travel as much.
Oh, okay.
So most of the time, what happens is here you don't have to go to the court every time, right? Most of the cases are settled.
Okay.
And you could appear for the cases of online also.
Okay. Okay.
Okay. And in some cases, we hire a local counsel to represent us. So I should learn a case in Washington, right? So we'll do whatever we can do from here. In case if you have to appear in court, then we'll hire a local counsel to appear in court.
So when we approach your office, we are going to talk to you in one-to-one or to your assistant. How is it?
Well, usually to my assistant.
Okay, and he decides, he screens who should come directly to you.
What's that?
He's going to screen. He or she is going to screen.
Yes. They will screen first. They will send you a checklist. They'll ask you to complete the checklist. Once they complete the checklist, then they'll share the draft with me to review it to make sure everything is okay. And then once I give the green signal, then they'll ask you to come here with witnesses, and then we'll just do the notary here.
Oh.
And sometimes we just send the document to, if they cannot come to the office, then we just email them the document, and then they sign it in front of a notary and 2 witnesses.
Okay. Now, in between, we approaching you, and then we need some confirmation or clarifications. So when we write, it's your assistant who is going to reply to us on that matter.
Emails?
Yeah.
Emails, I'll be replying to the emails.
Oh, okay.
Okay, but I would like I will have the assistant also being available on an email chain, so that she can, because I cannot remember all the cases.
Right. So,
and then as long as you're maintaining the same email chain, it will be much easier. But sometimes what happens is, out of the blue, somebody sends an email. I would not know anything about that case.
Okay. So she's familiar with the law.
Yeah.
Okay. Thank you very much. I had to ask you this. Yeah. Thanks. Thank you for your time, and thank you for advising us whatever you know. So that gives us the confidence to approach you and to see where we stand in life. Yeah. Thanks a lot.
Okay, thank you everyone for attending, and I think that wraps up our session today. If you have any more questions, feel free to email us at info@somireddylaw.com. Follow us on Facebook or Instagram to keep updated on our next webinars that we'll be conducting regularly. Hope everyone has a great night. Thank you so much.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.